as Zood had said, I am the directing attorney of the Public Law Center's Community Organizations Legal Assistance Project, which we call COLAP for short. For those of you who may not be familiar with PLC, we are a nonprofit legal services organization based in Santa Ana. In addition to providing legal assistance for underserved Orange County residents, we also provide pro bono legal services for nonprofit organizations who serve our clients, as well as providing very vital services for Orange County. So in addition to our services that we provide nonprofits, we also strive to be a legal knowledge base of those legal issues that affect your organization. So certainly AB5 matters that we're going to be talking about this morning, but also all of those legal issues that you're being hit with right now due to the upheaval in our lives due to the COVID-19 crisis. So I encourage you to reach out to Public Law Center, to me, with any legal needs you might find yourself in need of at the moment, whether it's AB5 related or something related to COVID-19. So with that, I am very pleased to have Michael Olson joining us this morning. Mike is an attorney with the employment and law practice of a local Orange County firm, Manhattan Phelps, the local Orange County office, national law firm. Mike is an expert on a wide variety of employment matters, including issues of employment classification, which is the subject that we're going to be looking at during today's workshop. So with that, I'm going to hand it over to Mike to share all of his knowledge of the ins and outs of AB5. So Mike, please feel free to carry on.
Mike, we can't hear you. You have to unmute your microphone. And everyone else needs to mute their microphone. We're hearing somebody who's not Mike, but we haven't heard Mike yet.
How about now?
There you go. Now we got you.
All right, good.
Okay, you want to, let's take it from the top. That was Sarah. Here's Mike Olson. Thank you.
All right. Sorry about that. And now I need to share my screen with you, and let's see if I'm doing that. Can you see my screen now as well?
Yes, we can see your screen
Okay.
fine. Thank you.
Great. All right. Sorry for the technical issue. So I'm going to be presenting on AB5 to you today. As Sarah mentioned, I'm an associate attorney in the employment practice at Manhattan Phelps and Phillips at Orange County office. And I'm happy to be presenting to you today. What I'm going to be covering is sort of the background, how we got to where we are with AB5 and what AB5 provides. AB5 came about because of increasing government scrutiny for contractor relationships, generally speaking. Between 2005 and 2015, this was cited by the legislator in adopting AB5. There was a 30% increase in workers classified as independent contractors in the state of California, and this is in large part due to the gig economy. But of course, the changes that were made in this law affect every employer. So first, how did Dynamex set the footprint for AB5? So Dynamex is the Supreme Court case we'll talk about. Who is an independent contractor under AB5? What occupations are exempt from the ABC test and under what conditions? What is sort of the future for AB5 and possible amendments? What steps should companies and employers be taking to be in compliance? So the original, or the sort of base test for who is an employee was established in 1989 under the under this case called SG Borello and Sons. The test at base was a control test. So there was no definition of employee in many labor laws in the country. So until this case, if an employer controlled the manner and means of work, then that person was considered an employee. So until this case, there wasn't really any further clarification on how to determine someone was an employee or not. And this case set forth some additional factors in addition to control that needed to be considered. So first, whether the person performing services is engaged in an occupation or business distinct from the principal, whether or not the work is a part of the regular business of the principal or alleged employer, whether the principal or the worker supplies the instrumentalities, tools, and the place for the person doing the work, the alleged employee's investment in equipment or materials, that is, are they supplying their own materials, whether the service rendered requires a special skill, and the kind of occupation with reference to whether in the particular locality the work is done under the direction of someone else or a specialist without supervision, the employee's opportunity for profit or loss, the length of time for which the services are to be performed, the degree of permanence of the working relationship, the method of payment, whether by time or by the job, that is, whether they're being paid hourly or they're being paid per finishing a particular job, and then whether or not the parties actually believe they're creating an employer-employee relationship. So as you can see, there are a variety of factors and the court set forth that needed to be looked at. These factors continue to apply. So you'll see when we talk about AB5, Borello will come into play still if the ABC test isn't applied, and I'll get to that in a moment. So in April of 2018, the California Supreme Court came down with this decision in Dynamex, in which it abandoned this test that had been in place since 1989. It abandoned the Borello test for the ABC test, and it said that this new test, the ABC test, would apply to any alleged violations of the Industrial Welfare Commission wage orders. So the IWC is promulgated these regulations. They are quasi-legislative. They govern wages, hours, and working conditions. There are 18 of them, and they're organized by industry and occupation. There's also a general minimum wage order and an order dealing with overtime. So the Dynamex test applies to violations of those, not to any other violations of the labor code. So this is the test that the Supreme Court, the California Supreme Court, set forth, and what is codified by AB5. So workers are presumed to be employees unless A, the worker is free from control and direction in connection with the performance of the service, B, the service is performed outside the usual course of business of the employer, and C, the worker is customarily engaged in an independently established trade, occupation, profession, or business of the same nature as the service performed. Now, many workers can comply with A and C, but B is problematic. So if the worker is doing the kind of thing that is similar to what it is that your organization or company does, then that person is going to be considered an employee under the ABC test. So some examples that were given by the Supreme Court of the ABC test and how it applies: if a retail store hires a plumber to repair a leak, they would be an independent contractor because the store is not in the business of plumbing. In comparison, if a clothing manufacturer were to hire a seamstress to work from home, they would not qualify. They would not satisfy the B-pronged because that's within the course what the employer or the company does. Same thing with if a bakery were to hire a cake decorator. Again, that's within the usual course of business of the bakery, and therefore that person is not going to qualify as a contractor because of prong B of this test. In short, prong B means that in order to be a contractor in California, you must be performing services that are ancillary to the primary thing that the business does. And this is why we saw a lot of uproar in response to this test. For example, with the gig economy, and you have drivers working for Lyft or Uber, for example. Again, those people are performing what the business does. I mean, of course, Uber and Lyft would dispute that, but that is an example of why this is a problematic test. So there are some interesting questions that arise from the Dynamex case, and first is whether this test applies retroactively. That means, does it apply to putative employment relationships that arose prior to April of 2018? We don't really have an answer to that just yet from the we don't have an answer to that yet, just yet. The issue has been sent to the Supreme Court, but the question is whether that really matters in light of AB5. So AB5, what it does is it codifies the ABC test that was articulated in Dynamex, and it expands that test. So it now defines the term employee throughout the labor code, not just the wage orders. Again, the wage orders are those quasi-legislative regulations that cover certain conditions related to work, such as minimum wages and overtime. But now it applies to additional things like workers' compensation, unemployment insurance, paid sick leave, and paid family leave. So these are all things that would now apply to someone if they qualify as an employee as a result of AB5. AB5 did not change the definition of employee for other provisions of California law, so Fair Employment and Housing Act, and a statute outside of the Labor Code, the California Family Rights Act. These things have their own test for who is considered an employee, and this test does not necessarily impact those laws. So the AB5 is codified in the Labor Code as section 2750.3, and the ABC test is in subdivision A1. And as you'll see, it's exactly the same as was set forth by the Supreme Court in Dynamex. So the individual must be free from control and direction of the hiring entity, and the work must be outside the usual course of the hiring entity's business. And C, the individual regularly and customarily engages in that trade, occupation, or business. So AB5 explicitly provides that it is retroactive as to the IWC wage orders and to violations of the Labor Code relating to wage orders. And it also applies retroactively to some exceptions. So the legislator has set forth some exceptions which allow the Borello test to still apply. And I'll go over those in a moment. So effective as of January, it applied to the Unemployment Insurance Code and other provisions of Labor Code. And effective in July, this test will now apply to workers' compensation as well. So if the legislator has created an exception and you satisfy that exception, you now have to use the Borello test to determine if an individual is an independent contractor or an employee. So this doesn't, so if you are able to satisfy an exception, it does not mean that that person is an employee. It just means that you get to use the Borello test. That is that 11 factors that are sort of wishy-washy. You can sort of balance them and argue that you satisfy those criteria. You're not automatically an employee just because you meet one of the exceptions that the legislator set forth. And so now I think I'm going to be turning to those exceptions. So many groups had lobbied to include their specific businesses or workers as accepted from the AB5 test. And of course, not all of them, oops, went too fast, not all of them got into the statute. So this is an example. It's sort of a hodgepodge of various different workers. So you have licensed insurance agents, brokers, and analysts, certain licensed healthcare professionals. So the statute specifies which professionals, like physicians and veterinarians, and it specifically states that those individuals are not included within the exception if they are subject to or potentially subject to a collective bargaining agreement. And the legislator's concern here with that exception and with all of the exceptions it created is that it did not want any organization or entity to be reclassifying any workers as independent contractors as a result of this legislation. So the idea is to save certain independent contractor relationships with these exceptions, not to create or allow the creation of more contractor relationships with these exceptions. So securities brokers, dealers, direct salespersons, and other licensed professionals by the state. And I've listed some of those there for you. And aside from the very specific industry-focused exceptions that I've just gone over, AB5 gives a couple of exemptions or exceptions for groups of folks. So one of them is professional services. So subdivision C discusses professional services. Contracts for professional services will be governed by Borello if certain criteria are met. And you must meet all of the criteria, not just some of them, and I'll go over those in a moment. The specific professional services that were included by the legislator are marketing, administration of human resources, and the legislator has also said that for these particular groups, marketing and human resources professionals, that the type of work that is contracted for must be varied and intellectual. That is, they can't be performing something that is standard or they're just following policies, because that would not be the kind of thing that the legislator wanted to accept. Other types of professional services include travel agent services, graphic design, grant writers, fine artists, payment processing agents through an independent sales organization. And for some of these, the legislator didn't tell us what they meant by that term. So for example, the legislator didn't tell us what they meant when they said a fine artist would be accepted as a professional service provider. So I've had discussions regarding what that means with a lot of folks, and it's not clear. It could mean just, for example, a visual artist like a painter, or it could be read more broadly to include, for example, a performance artist. But again, the legislator didn't tell us, so it just left to interpretation unless and until the legislator acts to clarify what these exceptions meant. So in order to qualify for the professional services exception, you have to satisfy some specific criteria. The individual has to have their own place of business separate from the hiring entity. And the legislator has said that that can include the individual's home, their home address that can serve as their own place of business. They can still choose to work out of whatever location that the organization has, but they have to have a separate place or address as well. Second, the individual has any license or permit that they need to perform work. So if they need a license to conduct business, if you've contracted with them for a period that lasts longer than 6 months, then you will want to make sure that that person has the necessary license or permit that they need. Otherwise, that's going to undermine the exception for you as the hiring entity, even though that's not really in your control. And I'll talk a little bit more about what you can do to mitigate that risk in a moment. Third, the individual has to be able to negotiate their own rates, so they can't be performing work according to like a schedule of rates that you have preset. That would undermine this exception. Fourth, the individual must be able to set their own hours. This doesn't mean that you can't set reasonable business hours. In fact, the legislator said that you can. You can require that a person perform work within certain hours. They are not sending you. They're not working only at midnight and you're not available, for example, or your customers or whoever it may be are not available. Fifth, the individual is customarily engaged in the type of work performed under the contract and holds themselves out to other clients as available to perform that work. So again, I'm sorry, I hear someone, I don't know if someone's trying to say something. Oh, okay. So
Please mute your microphones so that background noises don't come to the front and then interrupt. Thank you.
So so that's the professional services exception. And now the business-to-business service provider exception is subdivision E of this statute. And again, it provides us a set of criteria that have to be satisfied. So if you are contracting with another business, that other business, it could be a sole proprietor, or it could be another form of business. They're going to have to satisfy all of these things in order to qualify as a business service provider. So first, they are free from the control and direction of the business that's hiring them. Second, they provide services directly to the contracting business. That means they're performing their work for you as opposed to whatever customers that you are contracting with. Third, maintains a separate business location. The legislator did not say that, for example, a sole proprietor could use their residence as their separate business location for this exception. So it's not clear whether they left that out intentionally or not, or whether it's permissible. Fourth, customarily engage in independently established business of the same nature as the work performed. Again, negotiates their own rates. The contract is in writing. They have to actually contract with other businesses and maintain their own clientele. They have to advertise. They have to provide their own tools and equipment, and they have to set their own hours and location of work. Now, again, as with the professional services exception, these elements are problematic because it's difficult for a business to know if someone meets all of these and will continue to maintain or continue to meet those over time. One possibility for organizations or companies to comply with this is to, when they do their contract, to include representations and warranties that the individual or the business satisfies these criteria and will continue to do so, and that if any of those representations turn out to be inaccurate, that they will agree to indemnify the organization for that inaccurate representation and warranty. Another problem with these criteria is that they are too narrow. So for example, you may think that contracting with a business that provides IT services, that would be a legitimate business-to-business relationship. However, factor number 9, providing their own tools and equipment. Oftentimes, these types of contractors, they're working with the equipment that you have, the tools that you have. And so it is not clear that they would be able to satisfy all of those criteria here. I think I already mentioned that the maintains a separate business location. It's difficult. The statute doesn't specify whether this could be an individual's home. Now, with this exception, I would just caution that the statute says that individual workers cannot qualify for the business-to-business service provider. This seems to be a bit of a contradiction because they allow sole proprietors to qualify as businesses. If you are contracting with a business that is a sole proprietor, you just need to be clear that you're contracting with the business as opposed to the individual. It may be a very fine distinction given the nature of a sole proprietor, but since the statute excludes individual workers from this exception, that is just something that you need to be mindful of if you're availing yourself of this exception. And then the next exception that the statute addresses is a referral agency exception. So the ABC test will not apply if you have a relationship between a referral agency and a service provider. So the statute defines referral agency as a business that connects clients with service providers, and then it sets forth specific types of services that can be referred in this type of contract relationship. So graphic design, a tutor, if the statute says for a tutor, if they must create their own curriculum, so they're not just following the curriculum being provided to them by an organization, for example. Event planning, home repair, yard cleanup, moving, furniture assembly, and animal services. So again, another exception that might apply. And then again, there's very similar factors as we saw with the business service provider exception that must all be met in order for you to qualify for this exception. And I know I'm just moving through this kind of quickly, but again, we're going to share a copy of the presentation. I can share a copy of this presentation along with the video when we're complete here.
Mike, can I ask you a question real quick? Will this
Sure.
presentation be available as a PDF downloadable from your website?
I can make a PDF of this very presentation to share with folks.
I don't have well, I could figure out a place to host it on a website if you don't have one, but maybe if Sarah has a place on the public law website where it could be hosted, then I could provide a link.
Okay.
Sure, we could do that.
Okay, that would be great. Thank you.
So I sort of, as I said, there's just a great hodgepodge of exceptions here. So just given the audience, I haven't gone through every single exception that is in the statute. I've sort of just listed some of the others here so that folks are aware that these exceptions exist. And at the end, I'll provide my contact information as well if any of these apply. I'd be happy to talk in more detail with you about them. As you'll see, commercial fishermen, newspapers, cosmetology, there's a freelance journalism and photojournalism exception, which includes a cap on content submissions. So you can only have 35 content submissions to still qualify as a contractor. Construction subcontractors, and then contracts between motor clubs and certain professional services organizations. So yeah, if you have questions about any of those ones, you can feel free to ask either at the end or later by email to me. And then The legislator also set forth what the court recognized exception, which is essentially that if you are unable to satisfy an exception and a court determines that the ABC test should not apply to you, then you have the court could say that, okay, the Borello test just applies. So because of the nature of your business or whatever it is, whatever factors the court may consider, the court would be permitted to accept you from AB5, from the ABC test. But again, this would require litigation, which I assume that many organizations, nonprofits, are not going to be in a position to engage in litigation in order to take advantage of this exception. But it is in the statute. There is a recognition that there may be circumstances that the legislator didn't account for, but they would have to be created through litigation. So, and I just included some of so Lorena Gonzalez was the author, the main author of AB5, and immediately after the legislation was enacted, there was a big backlash. She's very active on Twitter. So this first guy here, he's a journalist. He's talking about the freelance journalism exception with a 35 article submission cap, and he is taking issue with that based on the nature of working in the newspaper industry, for example. And then other folks who are saying that the bill undermines their ability to earn a livelihood. So just some of that backlash there. And then Lorena Gonzalez responded to this by saying, very interestingly, she says, "I know that this law, like all laws, is imperfect. I obviously do not want to ruin anyone's current situation. We will continue to meet with folks and monitor implementation. In the beginning of this year, there will be a part 2 of this bill." So Gonzalez has introduced some legislation saying that basically just says they intend to do further work on this statute. We haven't seen, I have not seen anything come forward which delineates any further additional specific exceptions for specific groups. I know that there's been talk of various exceptions, which I'll talk about a couple of those. But there are further fixes coming this year. I'll just mention briefly, I know that, so there's an exception for the music industry, certain groups that do audio recordings, audiobooks, for example. This is one thing that is being considered as an exception. I just wanted to point out that if you are in any sort of organization where you are doing work for hire, that language, work for hire language, that is under the Federal Copyright Act, that creates a presumption under the Labor Code that someone is an employee for purposes of workers' compensation and unemployment insurance. So that language is already problematic. And so if you're in any sort of position where you're creating content of any sort, you may want to consider alternative intellectual property arrangements like licensing agreements or other sorts of ways of assignment of rights, that sort of thing. So we're expecting that the legislator will also address franchise relationships. We're expecting some further clarification on the business to business service provider exception. And there may be further, there's a lot of work in the film industry and the movie industry for writers, producers, that sort of thing. Again, it's unclear whether future fixes will be retroactive. So for example, if an exception comes down the pipe for nonprofits, it's not clear whether that exception will be made retroactive to the date of Dynamex when the law changed in 2018, or whether it's only going to apply prospectively from the date that the exception is created, so from 2020 forward. Just to go over some of, so there's sort of a several step process that any organization using contractors should go through as a result of there being this test out there. If you are trying to determine whether someone should remain a contractor, any analysis that you do, we recommend that you do with counsel, just because that analysis, if it's not privileged and someone decides to challenge your contractor classification, that analysis is going to be open to discovery if you do get sued over the use of contractors. So you'll want to see if your contractors meet the ABC test, and if not, whether you can meet one of the exceptions that I've discussed. And if you do, you need to still make sure that you meet the Borello test. What a lot of folks don't know is that there's a lot of organizations that did not meet the Borello test. That's those 11 factors plus control that I discussed earlier. So even if you meet an exception, you still have to meet the Borello test, and you need to meet as many criteria as you can, as meaningfully as you can, in order to ensure that those folks are properly classified as contractors. So if you do decide to, and you're able to convert people to employees, I know that a lot of smaller organizations may find it impossible to convert people to employees, but these are because of the cost, but I wanted to go over some of those with you. So things that you'll need to consider are rates of pay, what kind of benefits, if you have to provide benefits. So smaller organizations, even nonprofits, for example, are covered by the new coronavirus, the federal coronavirus legislation. So nonprofits smaller than 499 employees, they are required to provide folks with 2 weeks of paid sick leave, specifically related to COVID-19 under the Families First Coronavirus Act. So that's an example of a type of benefit that you wouldn't have to provide to someone who is a contractor that you need to consider if they were an employee. Workers' compensation insurance, coverage for employment practices liability if you choose to have that, other overhead costs, and then you would have to balance this with the cost of not complying. As well as the fact that when you convert someone to an employee, there may be questions about retroactive liability that you'll need to consider, whether you want to pay them some certain amount to make up for the fact that they were potentially misclassified before, and you'll need to consider what the cost of that would be in order to make up for that in some way. So here are just some of the penalties of not converting. So a worker who is misclassified can bring an action to recover unpaid wages for up to 4 years following the end of their employment. Some of the things that workers can recover for are unpaid and underpaid wages. So this includes overtime, double time. So in California, in terms of just overtime payment, people are entitled to pay overtime pay over 8 hours in a day, and double time pay over 12 hours in a day, and overtime over 40 in a week as well. Missed meal and rest periods, there's an obligation to provide meal and rest periods, and there's an hour of pay for a missed meal, an hour of pay for a missed rest period that an employee could be entitled to. Wage statement violations. There's a specific penalty for failing to provide a wage statement to someone, and it's a per wage statement violation. So depending on if you issue paychecks 2 times a month or once a month, the penalties can stack up quickly for failing to issue statements or do so appropriately. Workers can also recover for unreimbursed business expenses. So if they're driving to and from events for you, and they should be classified as an employee, you're going to be liable for the cost of reimbursing mileage to them. You may be liable for other things, for business expenses like the use of a personal cell phone. The California courts have held employees are entitled to a reasonable percentage of the cost of the use of a personal cell phone or data plan, for example, if they're using it for work purposes. So if they're found to be an employee, that's going to come into play as well. So here are some of the penalties. For willful misclassification, it is from $5,000 to $15,000 per employee. If there's a pattern or practice of willful misclassification, it's $10,000 to $25,000 per employee. There is also the Private Attorneys General Act, which provides additional penalties, and these are per pay period violations that stack up quickly as well. There are additional tax penalties that are provided by the IRS and California law for failure to withhold and pay payroll taxes, in addition to certain criminal penalties, such as being in prison for up to 1 year in California for failure to do so. I'll just note that these are sort of like worst case scenarios. These are really for flagrant violations of the law versus you're just a average organization and who didn't know better. These are for flagrant violations of the law, and for companies that you'll see these issues more often in industries and companies where there is an enforcement priority. So the gig economy is a huge area of enforcement priority for the state of California. They're targeting app-based organizations and companies, not your everyday, like your average nonprofit, your average small organization is not really a target of any of these things. If they become a target, these things then become a concern. I mean, the penalties are a concern if you are. They become a concern as well if you have someone who makes a claim. The penalties can come into play, for example, but you don't see that. Generally speaking, unless there's an enforcement priority, you're not going to see these sorts of concerns. Individual liability issues. The Labor Code provides for individual liability for officers, directors, and owners of organizations that fail to pay and are unable to pay their employees. It's sort of it's just one of the concerns that exists as well. Let's see. And these are just examples of class action settlements. I'm sure you have seen these these types of things in the news. They can be hundreds of thousands or millions of dollars where there is a misclassification. As I mentioned earlier, when you're converting someone to an employee, you're going to want to think about how you're messaging that. Because there may be questions about liability for being classified as a contractor. So whether you're going to offer them something in order to do away with your liability when you convert them. You may want to consider ways that you can still be flexible if you are implementing a change to employment relationships, such as part-time schedules and telecommuting, which we're all getting used to anyway. A lot of companies are having to grapple with with how to implement telecommuting as a policy, and those are things that you'll want to consider now more than ever as well. And I just discussed back pay versus risk of litigation. So some of the things that if your work can be done remotely, one thing that you might consider is the use of contractors outside of the state of California. If that is feasible for you, you might consider that as an option. If you are not able to comply with AB5, you might consider it temporarily until there are fixes which would reduce your exposure, such as an exception specifically for your type of organization. And I talked already a little bit about the litigation option. And this is just a summary of the steps that I've gone over. You'll want to first apply the ABC test, see if you can satisfy it for the folks that you do have classified as contractors. Second, you're going to want to analyze the costs of conversion. That includes everything that I talked about in terms of extraneous benefits, but also includes back pay, for example. The penalties of not converting, you'll want to weigh the cost of converting folks versus the cost of versus the potential penalties, and then how you're going to implement it practically. So how you're going to message it, whether you're going to implement back pay, and then lastly, if you can't actually satisfy the ABC test, if you might be able to use workers outside of California, for example, until there is some more certainty for you under AB5.
So I've been collecting questions for you, Michael. Is this a good time?
Yeah. So that's all of my presentation. So I'm happy to field some questions. I might not be able to answer very, very specific questions, but I can, with respect to individual situations, because I can't give legal advice on the call, but I can talk about what the statute provides and I can give some general answers. But I just want to caution that I can't provide legal advice since I don't have a attorney-client relationship with anyone I'm responding to.
No problem. So I'm just going to read what's been coming up while you were talking, so that, and some of them may have been answered in your presentation, but I took a note of them as they were coming up. So the first question that came up was, what if a business is a college counseling and the gig worker does English tutoring? Now, I know there was a tutoring exception, but does the tutor have to go through a third party, or can it be a tutor going through the college itself?
So, so I talked about tutoring in the context of a referral agency. There is no aside from the referral agency, there is no specific exception for tutors. And so unless that exception applies, then as with any of the exceptions that I've discussed, that means that you would need to apply the ABC test. And given that you are a college, chances are that a tutor is not performing services outside the usual course of what it is that you do, that they would not satisfy prong B of the ABC test and therefore not qualify as a contractor.
Next question, music producers who do not work for label but contract separately with artists, are they exempt? What is the definition of fine artist? And I know that I've been following this myself because I worked for many years in the arts, and I know that a lot of lobbying groups lobbied to have an exception in for artists, and they put in this exception fine artist, but they didn't make it clear. Is this still being discussed as to clarifying what fine artist means?
Yes. So the music industry, in addition to other entertainment industry groups, did lobby for an exception, given the existence of various groups. There were unions, for example. There were a lot of groups that were opposed to very broad exemptions or exceptions for folks in the music industry, and so no specific exception made it into the bill for that group. It still may happen. It's still out there, still being discussed. Instead, what we got is a very watered down exception, a very narrow, well, I don't know that it's narrow. We got the fine artist exception, and some folks read it very narrowly, but it's not defined in the statute. And so until we get further clarification, it's up to interpretation. But everyone should know that because of that, and because of the fluid situation in the legislature, that any interpretation we give may change in 6 months.
I know there are operas and theater companies that canceled productions because of AB5. They're talking about going under because of AB5. Has any of that been addressed by legislators?
It has not been addressed yet, and the legislator has been on a spring recess. So I haven't seen any new developments come in, but I anticipate that those things are going to be addressed, and it's just a matter of exactly what the language will be and when.
Well, so this kind of feeds into some other questions. I'm going to go a little bit out of order here, but somebody wrote, the law is problematic for churches to hire musicians for various services a few times a year, or even if they're just coming in one time. Maybe you have an outside cantor or an outside special guest musician. Has that been addressed at all?
So I guess I would query on that whether folks who are so you don't need an exception. So let me just say, you don't need an exception if you're able to satisfy the ABC test. So if they're performing work that is not part of what it is that you do, and it's still an open question what that means, but what is the main thing that you do? So is a church mainly providing musical service? I don't think so. Now you just need to look at the other factors to see if you satisfy those, the A and the C prong, and if you do, then you don't need an exception.
Somebody wrote, my understanding is that they're using the Department of Labor's definition of fine arts. Is that true, or has that changed?
So I've heard that, and I've read that interpretation as well. It's a reasonable interpretation, but it's not adopted by the legislator, and it's not been ruled on by any court. So there's nothing that says that is in fact there is no authority that says that is the definition. It's just one reasonable interpretation of the meaning.
Has this law affected volunteers in any way for churches or nonprofits, such as board members or committees that are maybe accepted?
So this law doesn't affect volunteer status. So traditionally, under state and federal law, a volunteer is someone who is providing their services without expectation of payment, and it's for a charitable or nonprofit, or it's for a religious organization. So if they qualify as a true volunteer, that is, they don't expect payment, and it's for some charitable humanitarian cause or religious reason, that test is still the same. So you could still be a volunteer. It's not affected by AB5 at all.
So a lot of organizations hire speakers, especially religious organizations may have religious speakers come through and speak at meetings, but the same with organizations. I speak at a lot of meetings. Our one-time events with speakers coming in, say authors, does that fit with AB5?
Again, I think that this is something that could potentially fit within the ABC test as codified by AB5. So again, it just depends on whether if you are an organization that solely connects speakers to events, so you provide some sort of speaker service, then maybe you would have a problem satisfying the ABC test. But otherwise, I don't see that as a problem.
Okay, I'm going to combine two questions. This is the last questions I have. So if you have any more questions, please put them in the chat box. Are we required to pay contractors by the hour? If a contractor is not paid by the hour, but by the gig, does it meets all the other exceptions? Is the payer in the clear?
Could you say that one more time? I'm sorry.
Are they required to pay contractors by the hour? Could they be paid by the gig if they meet all of the other parts of the ABC law? In other words, if you're hiring, say, a licensed counselor to come in, which falls under the exceptions, could they be paid by the job rather than by the hour?
Yeah. So the method of payment is not necessarily that's not a concern. So you could be paid hourly versus by the job. That is really so once. So let me taking a step back. So once it's determined that someone meets meets an exception, then you're going to look at the Borello test, and that's one of the factors under the Borello test, which is whether someone's paid hourly or by the job. And so if you're paying someone hourly, that could weigh in favor of finding that they are an employee versus a contractor, but it's not necessarily the case. So it's just one factor that is considered if you meet an exception.
Okay, great. This is the last question. Then Sarah is going to give us a short presentation. And then if you have any more questions, feel free to contact Sarah at the Public Law Center of Orange County, or Michael, I believe, has his contact through there as well. And then you're going to give me this PowerPoint or put it up somewhere where I can send out the URL to everybody that's on this call, correct?
Correct. That is correct. I will do that right after we're off of this call.
Great. So this is the last question for you. Have you seen mental health therapists? And that would be, I know there's an exception for doctors, and licensed professionals, but what if they're not a licensed therapist? Would they still qualify? Sorry, my chat window just moved. Would they still qualify for an exception if the therapist serves patients in a trauma treatment center, for example, and does not have their expertise on staff?
So I don't know that they necessarily qualify for an exception. So if they're not one of the designated healthcare providers that are covered by the exception, then again, you would just go to the regular ABC test, and if the work they're performing is outside the scope of what you normally do, which it sounds like, since they don't have the expertise on staff, then that should be fine. That should not be a problem.
But if they're a licensed therapist, then they're exempt anyway, correct? Because isn't that one of the exemptions was for licensed professionals in healthcare?
So the healthcare exception is a specifically delineated group of folks, and I don't believe a therapist was in that group. So I would have to look at the professional services exception statute, the language of that exception to verify. But the group includes doctors, dentists, veterinarians. It's a very limited group of healthcare providers. Not every person who is a healthcare provider.
I know there's a lot of people in our organizations who can't afford to have a PhD therapist come out who's a licensed doctor, but has maybe masters of social work professionals come out who've got their MSW and are licensed to be clinical care workers for, say, addiction therapy or something, or maybe at a battered women's shelter working with women who are domestic abuse survivors. So they would not qualify. They would have to be on staff. They couldn't be contractors working at several shelters.
I'm trying to, I'd have to look at the statute specifically to verify, but I don't believe they are in the group of folks listed as healthcare professionals under the professional services exception, which would mean that you just use the ABC test. But again, I'd have to look. I don't recall that being in the list, but it's been a while since I've looked at the text of the statute itself to verify, and it wasn't in my list when I made it. So I'd have to verify that.
So just for a little more clarification, if two organizations say share somebody for therapy, or three organizations, and they've been a contractor, could they work together to hire them where maybe they divide up their time, but they hire them under one agency and several agencies contribute to the salary?
Certainly, there's nothing prohibiting a joint employment type relationship. That would certainly be permissible.
Okay, I've got two quick questions that kind of got under the wire here. If you have a contractor sign that they qualify for an exemption and you know that they're not truthful, then what are the consequences?
If you have a contractor sign that
a contractor says that they qualify as a contractor, but they don't, and you know that, are there consequences for you?
So the representations, I was recommending that if you are going to have to avail yourself of a particular exception, that you include representations and warranties to ensure that if they don't or no longer qualify, that they are agreeing that it is that anything that flows from that is going to be on the contractor. Any consequence of that is going to be on the contractor. But if you know going into the contracting relationship that someone doesn't satisfy those criteria, it doesn't help you to include it as a representation because you already know that they don't, and therefore you would be improperly classifying them as a contractor by having them represent that they satisfy criteria. You know they don't.
So I have the last question that I think we've maybe answered a little bit, but you know, it gets back to this issue of fine artists. So if you have a dance company, a theater company, etc., that can't afford to hire their people full time, they know it doesn't qualify with the ABC test, but they just don't have the wherewithal to hire people. Do they have any kind of recourse, or do they just have to wait to find out what they clarify in terms of what a fine artist is for the exemptions?
Yeah, so I mean, it's partially just a part of your organization's own risk and your own tolerance and your own ability to your own determination about what you want to do, because some folks have availed themselves of the fine artist exception, saying, well, you know, that it could be interpreted broadly, while others have just said, well, I'm going to not do anything and I'm going to hold off and wait, and because I'm hoping for an exception, I'm hoping for something else to change in the law. So it's really up to the individual and their counsel whether they think that they can try to make an argument that they can use that exception.
I think the one thing that works in the favor of small organizations is that no lawyer is going to want to take the case because they don't have enough money to sue them. Whereas if you were like the LA Opera and you're making $3 million a year or $5 million a year, then you're much more suable.
Right, and I just say again, like, unless you have, you typically don't, not that you don't see it with smaller organizations, because I've seen it. I've seen claims, and they can be a big problem, which is why it's important to actually do this analysis. But unless you're like, you have people that are a problem, or you are in an industry that is a target of these sorts of of enforcement actions, you're much less likely to this to ever be a problem for you.
It could be a problem with your insurance, though, right? I mean, your insurance may not want to insure you if you're going to be a target of lawsuits.
Yes, yes.
Well, I see more questions about artists, but I think we've kind of covered that as much as we can, given that there's not a lot of clarity on it. So I'm going to turn it back over to Sarah. And before I do, everybody is muted, but they're wildly applauding right now, Michael, for you. And they're yelling and screaming, but you know, they're muted, so you can't hear them. But thank you so much for your presentation today.
You're very welcome, and I apologize that I have to drop off because I have another call. But thank you, everyone. It's a pleasure, and you have my contact information, and I will share the PowerPoint in a PDF form so that you can review it later as well.
And I see the applause coming from people. So thank you so much. It really is great to get some clarification. And I got to be honest, I've been following this ever since it blew up on my website. And I was surprised about a lot of this. And you've clarified things that I thought I knew, but I didn't know. So thank you for that.
You're very welcome. All right. Thank you, everyone. Bye-bye.
Okay. And everybody's saying, nice job, thank you. And I'm gonna turn it now over to Sarah. And by the way, if you liked Michael's presentation, you can also thank Sarah, because she's the one who is responsible for putting this all together with me and bringing Michael in. So I'll turn it back over to you, Sarah. Thank you.
Thank you very much, Sue. And I'm just going to share my screen. I have just a couple of slides to share with everyone. Let's see, is that up there?
It is, but it's very large. Maybe it's just the way that my screen is.
Let me see if I can make that smaller. How's that? Is that better?
I still can't see the whole word. Maybe somebody else can let me know through the chat if you're having the same problem as me. I'm only seeing, well, now I can only see the corner of it.
Oh, I see what the problem is. Okay, let's see.
Yeah, everybody's having the same issue as me. It's not just me. Are you on PowerPoint?
I have a PDF here.
Oh, I see what's going on then. So maybe you need to make it fit the window or something.
Okay.
Yeah, reduce the size on toolbar is what I'm hearing from people. And that's what I was saying too. Maybe there's a view where you can fit window.
Working?
There you go. Now it's happening.
There we go. Okay, thanks my tech gurus. Right. Well, that was a fantastic. Sorry, Mike left. Is a thank you in his absence to him. Great presentation. Well, he mentioned a couple of things to do after you conduct the analysis. You apply the ABC test to your situation, and it may be that you fit, you don't fit, you're not quite sure if you fit, and you're looking at options. So certainly he discussed litigation as an option, compliance, waiting it out even as an option, although that does come with its own risks. But he also mentioned the lobbying. Now, because most of the people on the call, I believe, are from nonprofit organizations, I wanted to just touch on this, maybe spend 5 to 10 minutes, because nonprofit lobbying in the context of nonprofit advocacy is one of those areas that can be problematic when it comes to for nonprofits. I just wanted to go through just some basic rules. So when it comes to AB5, so in the 7 weeks after the bill became law on January 1st, there were 34 separate pieces of legislation, all related to AB5, that were introduced in the legislature. So most of those bills were intended to expand on the list of occupations that would be considered exceptions, in which the employee would not, the worker would not be considered an employee of the business. There was one bill, which was, interestingly enough, did not seek to expand the occupation list, but actually sought to create a third category of worker. Okay, this is Senate Bill SB 1039. And interestingly enough, it was the one bill out of the 34 that was introduced by a Democrat. So does that mean it's more likely to pass? Possibly. The bill is still in committee. So it's we're not seeing a lot of traction yet, but as Michael said, the legislature is out on break right now, and we'll see what happens when they come back. That bill by Senator Galgiani is an interesting one because it does create this third category of independent contractor worker, which would have workers' comp protections, those workers would be entitled to unemployment insurance. So a lot of the worker protections that AB5 was intending to catch more California workers to provide those benefits to them that they had not been getting as ICs. So just something to keep your eye on. Now, when it comes to lobbying, I did say this can be a problematic area. So some of the questions I hear constantly is, I'm a nonprofit, can I lobby? I've heard that lobbying was prohibited by nonprofit organizations. And the answer to the question, can a nonprofit lobby, is yes. Nonprofits can certainly lobby. When it comes to 501c3 nonprofits specifically, there are limits. But first of all, I want you to know, yes, you can lobby. And certainly you can advocate for your clients and for your mission and for the purpose of your existence. But when it comes to lobbying specifically, this is an attempt to influence specific government decisions or actions. Okay, so for instance, with AB5, if you are intending to get behind a bill that expands A5 or creates this third party of worker, something that the legislature will be considering, that is a government action, so that would indeed be considered lobbying. Now, just to distinguish this from political campaigning is where an organization gets behind a specific political candidate, either in support of or in opposition of. For 501c3 nonprofits, this is absolutely prohibited. So just keep a distinction there in your minds. So, keeping that in mind, what can you do as an organization? What are some of the steps you can take when you're thinking about your advocacy strategy?
Can I interrupt you for a second?
Absolutely.
So we did a podcast on nonprofit lobbying with the head of the National Lobbying Group in Washington, D.C., and that podcast is going to be rebroadcast in a few weeks on our podcast site. So the same links for getting this, you'll see. As a matter of fact, I'll just move it up so that this is this week's podcast, and then that'll be the following week's podcast. So you can hear the difference between advocacy and lobbying and what you're allowed to do, which is most things. I mean, most people think you can't do anything, but you can actually do most things other than actual lobbying, which is very specifically defined. So I'll turn it back over to you, but I wanted to let them know that.
Yeah, absolutely. And I encourage everyone to, if you are planning to get engaged in lobbying around AB5 issues, especially if it's something your organization has not traditionally done. Now, some of you are maybe lobbying, that may be a regular part of what you do and in furtherance of your mission. But for those of you who haven't done it so far, really make sure that what your actions, the actions you're undertaking, are truly lobbying. Because that is when you need to, do things like keep track of your expenditures and other items. But if it's just straightforward education, general advocacy, that doesn't fall in this category. So, so the first thing to do, consider what you're doing. Is it really lobbying? If you are engaged in lobbying and you've not already taken the 501H election, and if you don't know what I'm talking about, that probably means you have not taken the H election, consider doing that. This allows you to institute a much more streamlined record-keeping process to keep track of your lobbying expenses and timekeeping. So if that, I don't want to go into too much of it here, but if that's something anyone has any questions about, feel free to reach out to me. I'm sure this is something that's going to be covered in the webinar Sue just mentioned as well. But either way, whatever track you take, keep very careful records of any expenditures any money that you spend on lobbying, and also time. So not only time of your staff members, but also volunteer time. because if you do not take the 501H election, you will need to submit volunteer time as well as staff time. So, so with that, just a few points I wanted to make sure everybody was aware of, but I'll be around for a few more minutes for questions. And while I am not nowhere near the employment law expert that Michael is, I'd be happy to field some questions on AB5 issues as well.
Just so everybody knows, the statewide lobbying group for the arts is California Arts Advocates, and you can look them up and you can follow their what they're doing to work on AB5 issues for arts issues. And the statewide lobbying group for nonprofits in general is the California Association of Nonprofits, run by Jan. I'm blanking on her last name right now.
Meduska, I believe.
Yes, and she was a speaker at our conference a couple years ago. Wonderful lady, really knowledgeable. Jan Masaoka, that's it. It's Masaoka. But anyway.
Zoot,
Yes.
I would also say, yes, definitely the Nonprofits Council, the Arts Advocacy Group. Also, if your nonprofit is in an area that's not arts related, you know, seek out are you involved in any advocacy groups? Do you have an association that covers the type of work you do? Because it very well may be that there's an advocacy group attached to your industry that is very much engaged in AB5 work. So you definitely reach out and see what's happening on that side.
And there most certainly is. I mean, there's an advocacy group for museums, there's one for preservationists, there's one for medical professionals that work in the nonprofit sector. So you pretty much, anything you can think of, there's probably an advocacy group attached to it. But the blanket one for nonprofits is California Association of Nonprofits, and they're working on this as well. Any questions for Sarah? I don't see any coming in the chat. So we will have this up within, I'm going to try to have this up by tomorrow as a podcast, by the end of the day tomorrow, I should say, because I have a lot of meetings today, but I'm going to try to work on this tomorrow and have it up by the end of the day tomorrow as a podcast and as a YouTube video by the end of the week. And I will be sending out, if you get my email blasts, I will be sending out information, and all of you who signed up through Eventbrite will get my email blasts. That's the price you pay for signing up for this free workshop. And then you can always opt out of it if you don't want them. But it will have all the links that were talked about, and Sarah's going to quickly put up Michael's presentation somewhere on their website and send me the link, and I'll make sure you get that as well. And I'll get that out to you hopefully by the end of the week, if not Monday. Does that sound fair, Sarah? Can we do that?
Yep, that sounds great.
Okay, great. Well, that being said, I think we're concluded. We've done everything we needed to do. Thank you all for being part of it. I want to thank Sarah and Todd at OCCF for making this possible. I'm Zoot Velasco from the Gianeschi Center. If you're interested, we have our workshop on COVID already up online. I sent you the link to that earlier in the chat, and you'll be getting more e-blasts from us. And we do a conference and a lecture series and a CEO training for nonprofit CEOs. So thank you all very much, and I look forward to seeing you on the next one. Have a great day.
Great. Thank you very much.